Hi guys, welcome back to Nairobi Legal Insights. In our video today, we're going to be discussing about oral wills that have been reduced into writing. This is a continuation of the previous video we had on oral wills in Kenya as far as Section 9 of the Law of Succession Act of Kenya is concerned. The two conditions that must be met for an oral will to be considered a valid oral will within the meaning of the Law of Succession Act of Kenya are that the person who makes this will must die within a period of 3 months, and this will must be made before 2 or more competent witnesses. Now, over and above that, we can have instances whereby a person can be on his or her deathbed and tells another person to write his wishes down on a piece of paper. So what happens to this will that has been reduced into writing, meaning that someone speaks out his wishes while another person takes note of whatever is being said. Now, one thing you need to note here is that even an oral will that has been reduced into writing will still be considered to be a valid oral will so long as the two conditions are met, and these are the conditions under Section 9 of the Law of Succession Act of Kenya. So what will happen in this instance is that the court will read the circumstances around the death of that particular person. Remember, his wishes have been reduced into writing, and we are going to be looking at a case that happened within the Republic of Kenya so that we appreciate to what extent can you say something while someone writes it down and it will be considered an oral will within the meaning of the Law of Succession Act of Kenya. As a student of succession law, this is the key case to consider reading so that you appreciate the principles that underlie reducing an oral will into writing and the consideration that the court will look at for this will to still be considered a valid oral will that has been reduced into writing. So what happened in the case of Rufus is that this gentleman was on his deathbed and he invited some of his family members and friends, and particularly Samuel was the gentleman who was given instructions regarding how Rufus wanted his property to be distributed amongst his family members. Now, in this particular instance, Rufus gave instructions while Samuel was noting down those instructions in the presence of the people who went ahead to actually sign at the end of that piece of paper. So, in this particular case, this was considered a valid oral will that had been reduced into writing because, again, it was conforming to the conditions stated out under Section 9 of the Law of Succession Act of Kenya. Remember that an oral will can be reduced into writing, but even that will that has been reduced into writing must conform to the requirements we discussed about under Section 9 of the Law of Succession Act of Kenya. So that is the key takeaway point from this particular case, and do not forget to read it so that you appreciate what happens if an oral will is reduced into writing and what will be the requirements that are needed so that this will that has been reduced into writing is considered to be a valid oral will. As we come to the end of this video, please remember that oral wills can be reduced into writing and they will still be considered oral wills, and do not confuse oral wills that have been reduced into writing for written wills. That is a whole different other topic that we're going to discuss in the next video. But do not forget again to read this particular case, and if you're watching this content for the first time, consider subscribing so that you receive notifications every single time we post a video on the law of succession in Kenya. Thank you.